Good day, my name is Juanne Bester and I am a legal advisor in the Consumer Protection and POPI Department of Pretoria.
Good day, my name is Melinda from Merwe and I'm also a legal advisor in the Consumer Protection and POPI Department. One of the objectives of the POPI Act is to promote the right to privacy. While South African courts have not yet dealt with the legislative interpretation of the POPI Act, the CCMA was recently confronted with a matter where the application of the POPI Act was raised. Juanne, can you maybe tell us more about the Sheburi versus Railway Safety Regulator matter that was before the CCMA?
Yes, Melinda. So, on the 2nd of March 2022, the CCMA handed down a ruling relating to an unfair labour practice dispute. The applicant, an employee of the Railway Safety Regulator, which is the respondent, alleged that she was excluded from receiving benefits that were due to her which other employees were entitled to. The respondent raised a point in limine, objecting that the applicant's bundle of documents contained confidential offers of employment of other employees that contained personal information of those employees, and she was not entitled to access and present those offers of employment to the Commissioner. The respondent submitted that the offers of employment were confidential information protected under the POPI Act. In responding to the point in limine raised, the applicant contended that the POPI Act was not applicable, as the Act does not apply to the processing of personal information related to the judicial functions of a court, and that the confidential documents were voluntarily made available to her by the employees to which they related. Therefore, the applicant contended that there was a valid consent to the processing of personal information. The respondent stated that the exceptions raised by the application in relation to the POPI Act was not applicable and that there was no proof that the employees had consented to the use of their personal information.
So, in making a ruling on the point in limine, the arbitrator held that the CCMA is not a court of law and therefore the exclusions in the POPI Act did not apply. Furthermore, the arbitrator held that the Act does not apply to the processing of personal information in the course of purely personal or household activity. And when presenting a case before the CCMA, the arbitrator argued that it will be seen as purely personal activity. Furthermore, the arbitrator held that when the POPI Act is applicable and when you have to apply the POPI Act is when you process personal information and enter it into a record by a responsible party. And the CCMA said that the applicant in this matter is not a responsible party as per the definition of the POPI Act.
So, Melinda, we can see from the facts that two important aspects were raised. Firstly, the processing of personal information based on consent, and secondly, the concept of processing of personal information for purely household or personal activity. So, Melinda, let's maybe discuss the first aspect, which is consent. The CCMA found that consent was in place for the disclosure of offers of employment. To this end, the CCMA reasoned that even though the emails of the employees made no mention of consent was indeed in place, given that these employees must obviously have been made aware of the fact that the applicant needed the information for a reason. They could, after all, have refused to give the documents to the applicant. But this in itself doesn't align with the POPI Act. The POPI Act requires consent to be any voluntary, specific and informed expression of will, in terms of which permission is given for the processing of personal information. So breaking this down, in order for consent to be valid, it must be an expression of will, be voluntary, be specific, and be informed. Considering the facts before the CCMA and from a POPI perspective, it ought to have been considered whether those individuals that provided Ms. Sheburi with the offers of employment agreed or consented to her using this during the CCMA proceedings. Consent can never be assumed. Melinda, can you maybe tell us more about the second aspect, which is purely household or personal activity?
Yes, Juanne. So, if you read Section 6(1)(a) of the POPI Act, which provides that the POPI Act is not applicable in processing of personal information in the course of purely personal or household activity. And it was found in presenting a case before the CCMA that it will be seen as purely personal activity, and therefore the POPI Act does not apply to CCMA proceedings. So the finding of the commissioner in that matter can be very questionable, because despite the POPI Act not giving us guidelines or a definition of purely personal or household activity, I would see it as an argument between an employee and another employee won't be personal or household activity.
So, although the POPI Act does not give us a guide on what constitutes personal or household activity, guidance can be obtained from the General Data Protection Regulation of 2016, which is the GDPR. The GDPR provides that purely personal or household activities are activities with no connection to professional or commercial activity and could include, for example, correspondence between family and friends or social networking activities. Legal proceedings before the CCMA generally arise between a dispute between an employer and an employee. This is a business relationship founded on a contract. Therefore, the CCMA proceedings cannot constitute purely personal or household activities, but follows from a commercial dispute.
Yes, Juanne. So it's clear from your argument when you talked about consent that consent must be informed, specific, and voluntarily. It may be argued that in this matter, consent wasn't specific because the employees, when they send that emails to each other, they didn't know that emails would be used in the CCMA matter. Furthermore, we can see that the applicant in this matter isn't a responsible party as per the definition of the POPI Act. So hopefully in the future, there will be more matters before the South African courts that will put this application to test so that we can see how we need to implement the POPI Act in our companies and how we need to apply the POPI Act in our companies in our matters and disputes.
So, Melinda, the question has to be asked whether the respondent was indeed concerned about the protection of personal information and privacy of those two employees, or was it not just an act to prevent the applicant from tabling evidence which could have been damaging to the respondent's case or company? The respondent's application for an order in terms of which the applicant is compelled to remove those two confidential offers of employment was, in essence, dismissed. Unfortunately, that is all that we have time for today. For more information on the requirements imposed by POPI and lawful processing of personal information, please contact your nearest CSR office for professional legal advice, or you can visit the link to our website.